If you spend any significant time discussing court opinions, you've encountered the concept of judicial review. What is judicial review? Where does it come from? And is it used today the way it was originally intended? These are questions every American should have a basic understanding of if they wish to live free. So that's what we're going to look at today in this episode of the Constitution Study. Hello there, everyday Americans. Welcome to the Constitution Study. This is where we read and study the Constitution, teach our action generation be free. I'm so glad you could join me. As always, you can find more information at the website constitutionstudy.com. And I'll talk a bit more about that after this episode. But for now, let's talk about this concept of judicial review. When it comes to understanding a term, the best place to start is with a dictionary definition. From the Free Legal Dictionary, judicial review is a court's authority to examine an executive or legislative act and to invalidate that act if it is contrary to constitutional principles. The power of courts to review the actions of the executive and legislative branches is called judicial review. Though judicial review is usually associated with the U.S. Supreme Court, which has ultimate judicial authority, it is a power possessed by most federal and state courts of law in the United States. The concept is an American invention. Prior to the early 1800s, no country in the world gave its judicial branch such authority. For a contemporary understanding of judicial review, this is an accurate definition. Is that the original understanding of judicial review, though? Is that what our framers intended when they drafted the Constitution? What does the Constitution say? Well, Article 3, Section 1 of the Constitution states, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish." So what is this judicial power the Constitution is talking about? The closest definition I could find from Noah Webster's 1828 dictionary is, the judiciary is that branch of government which is concerned in the trial and determination of controversies between parties and of criminal prosecutions, the system of courts of justice in a government. So where does this idea that the federal courts have the authority to invalidate acts of Congress or the president come from? What happened in the early 1800s to bring this power into existence? The answer is the case Marbury versus Madison. When John Adams lost his bid for re-election in 1800, he, along with other Federalists in Congress, attempted to pack the courts by passing the Judiciary Act of 1801 and appointing 16 new circuit judges and 42 new justices of the peace. While these appointments were approved by the Senate, their commissions were not delivered before the Jefferson administration was inaugurated. James Madison, Jefferson's Secretary of State, refused to deliver the commissions. When Marbury, one of the justices of the peace, petitioned the Supreme Court to compel Mr. Madison to deliver his commission via writ of mandamus. The Wex Legal Dictionary states, a writ of mandamus is an order from a court to an inferior government official ordering the government official to properly fulfill their official duties or correct an abuse of discretion. Does the court have the legal authority to issue such a writ? Well, that was the question the Marbury versus Madison court looked into. It has been insisted at the bar that as the original grant of jurisdiction to the Supreme Court and inferior courts is general, and the clause assigning original jurisdiction to the Supreme Court contains no negative or restrictive words, the power remains to the legislature to assign original jurisdiction to that court in other cases than specified in the article which has been recited, provided those cases belong to the judicial power of the United States. You see, lawyers playing games with words is nothing new. The Constitution clearly states that in all cases affecting ambassadors, other public ministers and councils, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction. But as to law and fact, with such exceptions and under such regulations as the Congress shall make. So the Constitution delegates original jurisdiction to the Supreme Court in this case, since it involves a public minister, the Secretary of State James Madison. Did you notice the twist? Congress can make exceptions for the question of jurisdiction and set regulations for the process of the court, but does that mean it can grant to the court a power not delegated by the Constitution? Again, from the opinion of Marbury versus Madison. To enable this court then to issue a mandamus, it must be shown to be an exercise of appellate jurisdiction or to be necessary to enable them to exercise appellate jurisdiction. This is an important question and what drove the court to the question of judicial review. The 10th Amendment to the Constitution is quite clear. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So if the Constitution does not grant to the courts the general power to issue writs of mandamus against other branches of the government, and it's not included as part of their jurisdiction, then Congress cannot give to the court a power not delegated to it by the Constitution of the United States. From the Marbury opinion, the authority therefore given to the Supreme Court by the act establishing the judicial courts of the United States to issue writs of mandamus to public officers appears not to be warranted by the Constitution, and becomes necessary to inquire whether a jurisdiction so conferred can be exercised. That brings us back to the question of judicial review. Chief Justice Marshall mentions judicial review in the Marbury opinion. It is emphatically the province and duty of the judicial branch to say what the law is. Those who apply the rule to particular cases must, of necessity, expound and interpret that rule. If two laws conflict with each other, the courts must decide on the operation of each. If, then, the courts are to regard the Constitution, and the Constitution is superior to any ordinary act of the legislature, the Constitution, and not such ordinary act, must govern the case to which they both apply. Notice the definition of judicial review used by Chief Justice Marshall. It's not a question of invalidating a law, but determining, in the context of a specific case, whether laws are in conflict with one another. And if one of those laws happens to be the Constitution of the United States, then it must win. Compare this with how courts use judicial review today. Again, from the Free Legal Dictionary. A court's authority to examine an executive or legislative act and to invalidate that act if it is contrary to constitutional principles. See the difference? Chief Justice Marshall made the point that in a case where both a legislative and constitutional law apply, the Constitution must govern the case. Yet today, that has morphed into courts invalidating laws they believe violate the Constitution. This is not a question of applying the law to a case before the court, but of the nullification of laws created by the representatives of the people. Chief Justice Marshall went on. Thus, the particular phraseology of the Constitution of the United States confirms and strengthens a principle, supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and the courts, as well as other departments, are bound by that instrument. The rule must be discharged. Yes, an act repugnant to the Constitution is void and invalid. Yes, the court claims that the rule must be discharged. But do you see the Chief Justice claiming that the courts can invalidate a law with a simple opinion, much less order the courts and departments to follow their opinion? Yet for as long as I've been following their decisions, courts have used this language not only to overturn laws of the United States, but to place their opinions above the law. The most blatant example of this violation of judicial review I can think of is the question of levels of scrutiny. Using the Free Legal Dictionary, let's look up strict scrutiny. In U.S. constitutional law, when a court finds that a law infringes a fundamental constitutional right, it may apply the strict scrutiny standard to nevertheless hold the law or policy constitutionally valid if the government can demonstrate in court that the law or regulation is necessary to achieve a compelling state interest. The government must also demonstrate that the law is narrowly tailored to achieve the compelling interest and uses the least restrictive means to achieve the purpose. Failure to show these conditions may result in a judge striking down a law as unconstitutional. The standard is the highest and most stringent standard of judicial review and is part of the levels of judicial scrutiny that courts use to determine whether a constitutional right or principle should give way to the government's interest against observance of the principle. The lesser standards are rational basis review and exacting or intermediate scrutiny. These standards are applied to statutes and government actions at all levels of government within the United States. Do you see the inversion here? According to Article 6, Clause 2 of the Constitution, this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. Yet today, using the concepts of judicial review and constitutional law, courts claim that they can overrule the Constitution if, in their opinion, the government has a good enough reason. Compare that to the origins of judicial review in the Marbury versus Madison opinion, and you'll see the courts have not only claimed to rule over the representative branches of government, but have placed their opinion and those of their predecessors above the supreme law of the land. Why has this abomination of the Republican form of government, not to mention the idea of self-government, been allowed to continue? Because those in the federal government, state governments, and yes, we the people are generally ignorant about the Constitution. We have all simply sat back while the oligarchy has been allowed to take over our republic. When was the last time you demanded that your representative in the House impeach a justice for such bad behavior? We should not use impeachment against every judge who issues an opinion we disagree with. That's not what I'm saying. I'm not talking about disagreements about the law, but the fundamental usurpation of the Constitution and the violation of the judge's oaths to support the Constitution. That borders on the level of a coup d'etat against the rightful law and government of this nation. So how can that be considered good behavior? Remember Article 3, Section 1 of the Constitution states, "The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior." I hope this explanation of judicial review, along with the abuses thereof, have opened your eyes to the tyranny of the oligarchs in black robes that currently rule over our country. I do not think it is an exaggeration to state that what the courts have done is usurp the Constitution, the supreme law of the land, and replace it with a government of their own design. Isn't it about time those we employ to represent us do their job to oversee the judicial branch? There is a reason why the only non-elected branch of the federal government was not given any power. According to Alexander Hamilton in Federalist Papers number 78, whoever attentively considers the different departments of power must perceive that, in a government in which they are separated from each other, the judiciary, from the nature of its functions, will always be the least dangerous to the public rights of the Constitution, because it will be least in the capacity to annoy or injure them. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or of the wealth of the society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend on the aid of the executive arm, even for the efficacy of its judgments. Isn't it time we the people, through our elected representatives, restore the courts to their rightful place in our government? Shouldn't we remove the force and will the courts have stolen from us and return them to a body of mere judgment? Unless we the people stand up to the long train of abuses the federal courts have committed against us and throw off such despotism, we condemn our children to live as subjects of an oligarchy rather than a free and secure people in a constitutional republic. As the Declaration of Independence reminds us, but when a long train of abuses and usurpations, pursuing invariably the same object, evidence, and design under absolute despotism, it is their right, it is their duty to throw off such government and provide new guards for their future security. I hope the next time you hear the word scrutiny or judicial review used in relation to a court case, you'll never think of it the same again. That you'll remember this episode and recognize this idea of scrutiny and judicial scrutiny is really the courts just saying how hard government has to work to steal your rights, to overturn the Constitution, overrule the supreme law of the land. Yes, it is that serious, and it happens pretty much every day from what I can tell. Our need to understand this, to hold our elected officials accountable for holding the judicial officials accountable to their oaths of office, is more important than ever. I'm not talking, as I said, about using impeachment for every opinion we disagree with. But when you have an entire judicial system based on the concept that a right protected by the Constitution can be overruled simply because they think there's a good enough, simply because they think the government has a good enough reason, then we're no longer a free people. We're no longer a constitutional republic, because now the laws and the rules and the ultimate power of this country is not vested in the representatives we elect, but in 9 unelected bureaucrats on the Supreme Court. And I don't know about you, but that scares me. Now, before I go, please, you can find this article and the video on the website, constitutionstudy.com. Please share it with friends and family on social media. We need to educate ourselves about the proper role of the judiciary. They do not rule. Federal judiciary, the federal appellate courts do not rule. They opine. And they took an oath to support the Constitution, not overturn it for their own convenience. We need to make sure they're held accountable. That includes me. Now, while you're over the Constitution, it's a great place to ask a question or sign up for one of the newsletters. Maybe even donate to the cause and help me continue to put out this great content and share it without charging people for it. Whatever you do, Share this with friends and family and social media. Encourage them to join you the next time right here on the Constitution Study.